Let's tackle a huge question for California nonprofits: fundraising without a license.
So can you actually fundraise in California without being properly registered? It's a big one.
And the short answer is a big, flat no. Trying to do it is a huge legal risk.
Yeah, this isn't just a guideline. You're violating the California government code.
First off, the Attorney General can hit you with an immediate cease and desist order.
And that means everything stops. Your online donations, mail, events, all of it.
But it doesn't stop there. The penalties for not complying can be really severe. We're talking up to $2,500 for each violation.
And look, if they think you're doing it on purpose, the stakes get way higher.
Yeah, that can jump to $50,000 per violation. Ouch.
And it's not just about fines. Leadership can actually face personal criminal liability.
Plus, any contracts your organization has, they could suddenly become legally unenforceable.
Okay, enough of the scary stuff. How do you stay compliant? It's just a two-step path.
First step, file that initial registration within 30 days of getting your first assets.
Then just file an annual renewal after your fiscal year ends. This keeps you in the clear.
All right, let's tackle a few common and kind of costly myths that trip people up. Myth 1. New orgs can wait. Nope, that 30-day clock starts with your very first donation.
What about small orgs? While you might be fee exempt, but you are not registration exempt. And that little donate button on your website, that absolutely counts as active solicitation.
Another big one, thinking your 501c3 is enough. It's not. They're two separate things.
So to fundraise legally, you really need to think about it as a solid three-sided structure. This is the California Compliance Triangle: the AG, the Secretary of State, and the IRS.
Just being good with the IRS and Secretary of State isn't enough. You need the AG's okay.
So the real question is your nonprofit built on that solid foundation? It protects everything.